The Senate will come to order. I ask everyone present to please rise and recite the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. In the absence of clergy, let us bow our heads in a moment of silent reflection or prayer. Reading of the Journal.
In Senate, Tuesday, January 17, 2023, Senate met pursuant to adjournment. Journal of Monday, January 16th was read and approved. On motion, Senate adjourned.
Without objection, the Journal stands approved as read. Presentations of petitions, messages from the Assembly.
Senator May moves to discharge from the Committee on Rules. Assembly Bill number 607 is substituted for the identical Senate Bill 820. Third reading counted 29.
Substitution so ordered. Messages from the Governor. Reports of standing committees. Reports of select committees. Communications and reports from state officers. Motions and resolutions. Senator Gineris.
Good morning, Madam President. Let me welcome Senator Griffo to the floor leader chair on the Republican side. It's a pleasure to work with him today. I move to adopt the resolution calendar.
All those in favor of adopting the resolution calendar, please signify by saying aye. Aye. Opposed, nay. The resolution calendar is adopted. Senator Gineris.
Please take up the calendar at this time.
The Secretary will read.
Calendar number 26, Senate Print 817 by Senator Hoyman Siegel, an act to amend the elder law.
Read the last section.
Section 2, this act will take effect in the same. This act will take effect in the same date and in the same manner as the laws of chapter 2022.
Call the roll.
Addabbo, Giannaris Kruger, Ort, Stewart Cousins, White.
Announce the results.
Lanza, Waltrip.
Ready. Announce the results.
In relation to calendar 26, those senators voted in the negative are Senators Lanza, Oberacker, Ort, and Walzett. Ayes 55, nays 4.
Okay. The bill is passed.
Calendar number 29, Assembly number 607 by Assemblymember Barrett, an act to amend the chapter of the laws 2022.
Read the last section.
Section 2, this act shall take effect on the same date and in the same manner as the chapter of the laws 2022.
Call the roll.
Addabbo, Giannaris Kruger, Ort, Stewart Cousins, White.
Announce the results.
Ayes 60.
The bill is passed.
Calendar number 30, Senate Print 821 by Senator Harkin, an act to amend the tax law.
Read the last section.
Section 2, this act shall take effect on the same date and in the same manner as the chapter of the laws 2022.
Call the roll.
Addabbo, Giannaris Kruger, Ort, Stewart Cousins, White.
Announce the results.
Ayes 60.
The bill is passed.
Calendar number 33, Senate Print 824 by Senator Sanders, an act to amend the insurance law.
Read the last section.
Section 7, this act shall take effect immediately.
Call the roll.
Addabbo, Giannaris Kruger, Ort, Stewart Cousins, White.
Announce the results.
Ayes 60.
The bill is passed.
Calendar number 34, Senate Print 825 by Senator Hoyman Siegel, an act to amend the insurance law.
Read the last section.
Section 5, this act shall take effect immediately.
Call the roll.
Addabbo, Giannaris Kruger, Ort, Stewart Cousins, White.
Announce the results.
In relation to calendar 34, those senators voted in the negative are Senators Griffo, Ort, and Tedisco. Ayes also Senator Steck. Ayes 56, nays 4.
The bill is passed.
Calendar number 70, Senate Print 101 by Senator Ryan, an act to amend the vehicle and traffic law.
Read the last section.
Section 9, this act shall take effect 1 year after it shall become a law.
Call the roll.
Addabbo, Giannaris Kruger, Ort, Stewart Cousins, White.
Announce the results.
In relation to calendar 70, voted in the negative, Senator Oberacker. Ayes 59, nays 1.
The bill is passed.
Calendar number 71, Senate Print 177 by Senator Gianaris, enactment of the banking law.
Read the last section.
Section 2, this act shall take effect on the 180th day, it shall become a law.
Call the roll.
Addabbo, Gianaris, Kruger, Ort, Stewart, Cousins, White.
Announce the results.
In relation to calendar 71, those senators voted in the negative are Senators Gallivan, Helming, Oberacker, Ort, Palumbo, Steck, Tedisco, and White. Ayes 52, nays 8.
The bill is passed.
Calendar number 72, Senate Print 492A by Senator Comrie, enactment of the Public Authorities Law.
Read the last section.
Section 7, this act shall take effect on the 120th day, it shall become a law.
Call the roll.
Addabbo, Gianaris, Kruger, Ort, Stewart, Cousins, White.
Announce the results.
In relation to calendar number 72, those senators voted in the negative are Senators Borrello, Helming, Murray, and Palumbo. Ayes 57, nays 4.
The bill is passed.
Calendar number 74, Senate Print 564A by Senator Kavanaugh, enactment of the banking law.
Laid aside.
Calendar number 78, Senate Print 935 by Senator Kennedy, enactment of the real property tax law.
Read the last section.
Section 2, this act shall take effect on the 90th day, it shall become a law.
Call the roll.
Addabbo, Gianaris, Kruger, Ort, Stewart, Cousins, White.
Announce the results.
Ayes 61.
The bill is passed.
Calendar number 80, Senate Print 967 by Senator Ryan, enactment of the real property tax law.
Read the last section.
Section 2, this act shall take effect immediately.
Call the roll.
Addabbo, Gianaris, Kruger, Ort, Stewart, Cousins, White.
Announce the results.
Ayes 62.
The bill is passed.
Calendar number 82, Senate Print 1065 by Senator Mayer, enactment of the banking law.
Read the last section.
Section 2, this act shall take effect 1 year after it shall become a law.
Call the roll.
Addabbo, Gianaris, Kruger, Ort, Stewart, Cousins, White.
Announce the results.
In relation to calendar 82, those senators voted in the negative are Senators Borrello, Griffo, Oberacker, Palumbo, Steck, Tedisco, Walzik, and White. Ayes 54, nays 8.
The bill is passed.
Calendar number 83, Senate Print 1144 by Senator Sanders, enactment of the banking law and the penal law.
Read the last section.
Section 11, this act shall take effect on the 30th day, it shall become a law.
Call the roll.
Addabbo, Gianaris, Kruger, Ort, Stewart, Cousins, White.
Announce the results.
In relation to calendar number 83, those senators voted in the negative are Senators Ashby, Borrello, Gallivan, Griffo, Helming, Matera, Murray, Oberacker, Ort, Palumbo, Rollison, Steck, Tedisco, Walzik, and White. Also, Senator Lanza. Ayes 46, nays 16.
The bill is passed.
Calendar number 84, Senate Print 1242 by Senator Felder, enactment of the vehicle and traffic law.
Read the last section.
Section 2, this act shall take effect on the 1st of April.
Call the roll.
Addabbo, Gianaris, Kruger, Ort, Stewart, Cousins, White.
Announce the results.
In relation to calendar 84, those senators voted in the negative are Senators Borrello, Gallivan, Griffo, Helming, Kruger, Ort, not O'Mara, Walzik, and White. Ayes 54, nays 8.
The bill is passed. Senator Gianaris, that completes the reading of today's calendar.
Please, let's move on to the controversial calendar.
Secretary will ring the bell. Secretary will read.
Calendar number 74, Senate Print 564A by Senator Kavanaugh, enactment of the banking law.
Senator Borrello.
Yes, Madam President, would the sponsor yield for a question?
Sponsor yield.
Yes, Madam President.
The sponsor yields.
Thank you, Madam President. Through you, Madam President, Senator Kavanaugh, thank you. We were just discussing debating yesterday, and here we are today. So, oh, happy birthday also. So, I'm done with my questions. No, I'm kidding. No.
I think of a better activity to be doing on my birthday.
So I have some concerns with this. Obviously, when you start talking about lenders, we already are seeing pressure with rising interest rates. Mortgages are obviously part of the American dream, being able to own your own home, and I have some concerns. Can you first, we were talking about basically holding lenders liable for a number of things, well beyond what the current laws are and well beyond even federal limitations. But could you talk about material noncompliance? Can you really, there's no definition in this bill on what material noncompliance really is. Can you please tell me what that means?
To you, Madam President, yes, we debated this bill on this floor, I believe it was last year, and one of the concerns that I heard from the other side of the aisle was that the bill was written in such a way that it said noncompliance, and there was an implication that any noncompliance at all with the regulations or the law would result in adverse impacts on lenders and mortgage servicers. So we've added a provision that specifies that the violation has to be material. So the private right of action in this bill would require that the borrower, the homeowner bringing the action, would have to show that they've been injured and meet the other requirements of that one would normally that are common in litigation. But in addition, they'd have to show that any violation is material. There is not, as has been noted, we don't specify what material means in this context because there are many different regulations. But materiality is the notion that it has to be non-trivial. It has to be significant. It has to have, it can't be a sort of de minimis injury. There has to be a significant injury, a real, what we would think of as a real injury. But that is the sort of thing that judges and litigants have to work to establish on the merits all the time.
President, sponsor, continue to yield.
The sponsor yield.
Yes, Madam
The
President.
sponsor yields.
Through you, Madam President. So we're creating a private right of action, which we don't currently have, which means anyone can bring an action against a lender, a borrower. So when you do that, so you're saying that we really don't have a definition for what material noncompliance is and a definition of an injury. So essentially, there's going to have to be litigation, and a judge will have to determine what material noncompliance would be. Is there any way to cure this without having to go to litigation?
So first of all, it's not true that anyone could bring, anyone is entitled to assert that they have an action, but in order to have an action, you would have to be someone who has been a homeowner, typically, somebody who has received mortgage funds. You'd have to be someone who has been injured by reason of a violation of the rules and regulations. That's what, so this creates, to the extent this is creating something new, it is creating this notion that if you are injured because your lender or your mortgage servicer has violated the law, then you have some recourse in court, and that is the core purpose of the bill. In terms of having to litigate once, if you're a homeowner and you decide you've been injured, yes, you have to litigate. You're gonna have to litigate the question of really whether you've been injured. You're gonna have to litigate the question of whether this party that you're suing has in fact violated the law, and you're gonna have to litigate whether that violation is a material violation or, say, a trivial violation. And yeah, that's it. So we have added, again, partly in response to some concerns we heard on this floor from the other side of the aisle last year, we've added an additional element that the plaintiffs, the people bringing the action, would have to demonstrate because, we heard last year that there was no standard that said the violation had to be a meaningful violation. So we've decided to add that. So yes, it does add another element that needs to be litigated, but litigation is the way parties decide who's been injured and to what extent there's recourse. In terms of your question about cure, there are provisions in the state law for some of the violation, for some of the rules that the violation of which could be a predicate for a suit in this, for this private right of action we're adding. There are in some cases provisions that specify how one might cure a violation of that provision. That approach is also paralleled in some of the federal law. And I would note there is a private right of action under federal law already. There's also private rights of action in Ohio and California. So this is not novel. We're not, doing something to lenders in New York that hasn't happened in other places and indeed isn't available under federal law in every state in the country. But so in some circumstances, somebody may have violated and then cured it. Presumably, you'd be hard pressed to say you've been injured if the injury has been cured. But again, I think all of that would be the significance of a cure or a failure to cure, I think would be something that the parties would have to litigate.
Madam President, will the sponsor continue to yield?
Does the sponsor yield?
Yes, Madam
The
President.
sponsor yields.
So I just want to dig a little deeper on this. You're saying then that there would be an opportunity to cure. In other words, if it was a mistake, an honest mistake, they could fix that mistake, and that would then cure the injury from a legal standpoint?
Again, I don't want to prejudge how the judiciary would view this, and in another in the building across the street, people are discussing how the judiciary is going to be managed in the next in the coming years. But what I'm saying is that there are, in some cases, there are provisions that are in the rules that are referenced in this bill, where the provision itself specifies how to cure a violation of that. So there are some circumstances where there's black letter law that says, if you violated this, you may cure it in this way. And that's true at the federal level, it's true at the state level. This bill does not add a general purpose cure provision that says if you cured it, you're fine. Presumably courts would be empowered to determine whether efforts a party that violated the rule, whether their efforts to, compensate the borrower, whether efforts to cure the violation are relevant to the question of whether the person's been injured and whether the violation is material.
Madam President, will the sponsor continue to yield?
Does the sponsor yield?
Yes, Madam President.
Sponsor yields.
So if a non-compliance is discovered and it's cured by the servicer, the lender, would that still essentially forever bar them from foreclosing? In other words, if there was a violation but it was cured, are they now barred from being able to foreclose?
So if somebody has violated the law and the regulations that they're violating provide for a cure, and they do what's necessary to cure the violation, the way I would think about it is at that point they are not in violation of the regulations. And again, there would also have to be, presumably, there would have to be an injury that the party is asserting. So if somebody, borrowed money from you and didn't pay you back, and then they paid you back, you'd be in a, maybe I shouldn't use a borrower analogy, but if a violation has occurred and then the violation has been cured, presumably the cure diminishes the extent to which you're able to assert that you've been injured by the violation. But again, the DFS has power. This bill references statute, but also regs. DFS does have the power to specify under what circumstances someone is effectively curing. My assumption, and again, it's possible that somebody in the judiciary would read this differently, but my assumption is if you cured a violation, it would be such that the borrower is no longer injured by the violation, and so they probably wouldn't have a cause at that point.
Thank you. Madam President, will the sponsor continue to yield?
Does the sponsor yield?
Yes, Madam President.
The sponsor yields.
Thank you. Through you, Madam President. So you bring up DFS, and in fact, loan servicers are regularly examined and penalized by DFS. So what's the purpose of this bill if we already have a procedure in place to ensure that servicers are being honest and doing their job?
This bill is to ensure, through you, Madam President, to ensure that homeowners who have been injured by a failure of lenders or mortgage servicers to follow the law, that those people, when they've been injured, they have some recourse.
Madam President, will the sponsor continue to yield?
Does the sponsor yield?
Yes, Madam
The
President.
sponsor yields.
All right, so thank you for that. So I'm going to go back to the private right of action. You know, this is a concern of mine on so many bills that we have here, that we are creating fertile ground, in my opinion, for frivolous lawsuits. So let's say a mortgage servicer has created some kind of a technical violation. They gave a notice incorrectly or, you know, a little late. Could conceivably this create a situation for a class action lawsuit? In other words, this ABC mortgage lender sent a notice out, you know, 30 days late, and now everyone is in a class to create a class action lawsuit by a law firm against that servicer, and essentially could be, you know, financially devastating if every loan that they have out or within a certain period of time is now subject to a class action lawsuit, or even a group of lenders. So my concern is that and the potential impact, because that could be certainly a big money situation, and you know, could break the back of an individual lender potentially.
Hypothetical, perhaps you can elaborate a little more. In the hypothetical, what is the injury that I'm sorry?
A late notice to borrowers, a required notice.
Okay, so again, through you, Madam President, in my mind, a late notice would be a violation of the law. It would have to be determined whether that late notice is material, but also they'd have to demonstrate. The bill we have in front of us clearly distinguishes between the notion that you're violating the law and as a result of that violation, the borrower is injured. So a 30-day late notice, a borrower in that circumstance would have to demonstrate that they'd in fact been injured by that notice. And I guess it's conceivable that they had been. Maybe they lost a great deal of money as a result of that late notice. I'm not sure of the circumstances, this is hypothetical, but if somebody, we're saying if a homeowner loses a lot of money or has some other injury to them, and that injury is not cured in some way, then they have recourse. And if thousands of people are injured in that way, a class action is the mechanism. As I'm sure my colleague knows, it's not so easy to certify a class and get a class action going. But a class action is the mechanism when very large numbers of people have been injured in a way that is sufficiently similar that a class action is the most efficient way for the judiciary to do it. I don't think there's, this statute is more likely to lead to class actions than numerous other statutes we passed. But yeah, that is the mechanism for that.
Thank you. Madam President, on the bill.
Senator Borrello on the bill.
Senator Kavanaugh, thank you again for the birthday debate. So appreciate it. I look at bills like this and others, and I say to myself, what is the goal? The goal is to protect consumers, and I get that. But when you do things like this, you limit choice, you raise costs. And that, to me, is a bigger injury to consumers. This and so many other bills that we vote on creates a private right of action, which creates fertile ground for frivolous lawsuits. Now, last week in this chamber, we had a very vigorous debate on why we should limit the ability for someone who feels that their constitutional rights have been violated. Instead of having a choice of 62 counties to bring their lawsuit, it should only come down to 5. Because we wanted to streamline the process and reduce frivolous lawsuits. Yet, since that bill was debated, I'm counting this as the 3rd bill that creates more opportunity for frivolous lawsuits. Now, you might say to yourself, well, what's a material violation? Well, that's a good question, but it may cost money to get that answer through litigation. And in the case of a class action lawsuit, you could create a situation where a minor violation, a notice that was sent out to all borrowers, was illegal because it was a few days late. That now creates a situation for a class action lawsuit. Now, maybe the result isn't that the company has to refund all the mortgages. That would be unreasonable, but it could be, like as we've all experienced, as all of us probably have been part of a class action lawsuit, that I get a check in the mail for $1.86 that I probably never bother cashing, but the law firm made hundreds of thousands, if not millions of dollars in that process. And that's what this type of legislation incubates, in my opinion. But when you start talking about mortgages and the ability for someone to own a home in New York State, there's kind of a sense of arrogance, in my opinion, that everybody wants to do business in New York State because this is the great state of New York. Well, that's just not the case. We're seeing that every day. We see businesses leave New York State every day because they can't do business here. They can no longer afford to do business here. But in the case of mortgage lenders, that means less people are going to have the ability to own a home in this state. And that, to me, is a real tragedy because that is the American dream. So I'll be voting no on this, and I'll certainly be encouraging my colleagues to do the same. Thank you, Madam President.
Thank you, Senator. Are there any other senators wishing to be heard? Seeing and hearing none, debate is closed. Senator Gineris.
By agreement with our colleagues across the aisle, we are returning this bill to the non-controversial calendar. So if we can please do that and take it up for a vote.
The bill is restored to the non-controversial calendar. Read the last section.
Section 2, this act shall take effect on the 30th day and shall become a law.
Call the roll.
Dabo, Giannaris Kruger, Ort, Stewart Cousins, White.
Senator Kavanaugh to explain his vote.
Thank you, Madam President, and thank you for the opportunity to debate today and, you know, a good, lively discussion. I would note that last year's debate has resulted in specific amendments to the bill, so we always appreciate the opportunity to discuss it. Just to say again, this is about circumstances where lenders and mortgage services are violating the law and it is harming homeowners. It is true that any cause of action, that any law that creates a opportunity for people to bring a legitimate cause of action also creates the opportunity for people to claim they've been injured when they hadn't, and they haven't. But we have had cases in New York where mortgage servicers have aggressively and apparently intentionally charged fees to homeowners that were legally impermissible. We have had commentary in our courts that say, you know, it's up to the legislature to determine whether there ought to be a private right of action. And it is, you know, it's the judgment that's reflected in this bill is that homeowners who are also facing the challenges that that my colleague mentioned, you know, the rising interest rates and the, you know, difficulties in the economy should have some ability to assert their rights. That's what this bill is about. I would note again, there are private rights of actions at the state level in at least 2 other states, including the largest state in the United States, California, and certainly Ohio. And also there is a private right of action under federal law. So this rash of frivolous litigation, you know, many people in America have a right to sue right now under federal law, and they have a defense under federal law, and that has not led to the kind of this kind of pernicious, frivolous litigation that we're talking about here today. Again, so I vote aye, and again, I thank the leader and my colleagues in the House for supporting this bill.
Senator Kavanaugh to be recorded in the affirmative. Announce the results.
In relation to calendar 74, those senators voted in the negative are Senators Ashby, Borrello, Gallivan, Griffo, Helming, Lanza, Matera, Murray, Oberacker, Ort, Palumbo, Rollison, Steck, Tedisco, Walzek, Weber, and White. Ayes 45, nays 17.
The bill is passed. Senator Gineris, that completes the reading of today's calendar.
Is there any further business at the desk?
There is no further business at the desk.
I move to adjourn until Monday, January 23rd at 3 p.m. with the intervening days being legislative days.
On motion, the Senate stands adjourned until Monday, January 23rd at 3 p.m., with intervening days being legislative days.